Hello and welcome to the Restart Michigan webinar, Employer Obligations as Michigan Gets Back to Work with Dykema. I am Lori Ostro, Senior Director of Engagement with the Detroit Regional Chamber, and I thank you for joining today's session. The Chamber launched this series of webinars to help businesses across the state prepare to restart operations and return to work. I would like to thank our guest speaker from Dykema for volunteering his time to share his expertise. Before we get started, I wanted to make you aware that all of the participants are on mute, but you can submit your questions via the question box in your control panel. I will now turn the webinar over to James Hermon from Dykema.
Thanks, Lori. I appreciate the opportunity to present with the Chamber today. Employers across the state are confronting the reality of bringing people back to work after being out for in excess of a year at this point. And we're finally moving away from those stay-at-home orders, but there are still a lot of restrictions in place and a lot of things that employers need to think about and do. I'm going to focus on the law in Michigan today. Obviously, there are some people attending that may have offices in other states or even other countries. And so it's important that you confer with your local counsel about what's going on in those places to make sure that you're in compliance there. But given the nature of our attendees today, it seemed like focusing on Michigan was the way to proceed. So there's a few things I want to accomplish today. First, I want to discuss the new emergency MIOSHA rules that came out and that were effective on May 24th, because there are still a number of requirements that need to be complied with. Second, I want to talk a little bit about vaccination, what you can require your employees to do and to disclose and how you go about doing that. I want to go over a few things to think about as you're looking at returning your employees to work, and then also go over some commonly asked questions. And then I've saved some time at the end for any questions that people may have. We have put a question box over on the left-hand side. I see we had our first question come up. I'm going to try to answer those at the end. Like I said, I've saved some time to go back and do those, and we'll get through as many of them as we can while being respectful of your time. By necessity, I'm going to get through a lot of generalities today. It's going to be impossible to get into specific questions with people in specific situations and all circumstances, but I'll do my best to be as specific as I can in addressing questions that may come up. It's been a really long 15 months. As I was getting ready to do the presentation today, I went back into some old presentations that I had just to grab some templates out of them, and came across one what we did on March 11th of last year, when we were talking about this new COVID-19 thing that was breaking out and how our employer is going to deal with it. And one of the slides we had, and this was the date that actually the pandemic was declared by the World Health Organization, was the one that you see here, the states reporting cases of COVID-19 to the CDC. And at the time, we were all extremely alarmed that we had, 100 cases to 200 cases in California and New York, and over 200 cases in the state of Washington. And it was of great concern. And you look at those now and think about, if we had numbers like that happening, we just call this thing done and we'd be finished with it. So thinking about how far we've come is really amazing. Since then, this thing has exploded and everyone realizes that. We've had more than 33.2 million cases of COVID-19 in the US. That's about 10% of the population. Likewise, we've had about 1 million cases in Michigan, which is likewise about 10% of our population, over 170 million cases worldwide. That's only what's being reported. Obviously, there were a lot of cases that were missed in the early days of the pandemic, and they continue to be missed in places where testing isn't robust, like India. So the numbers really are significantly higher than what we're seeing. Likewise, we've had more than 590,000 deaths tied to COVID-19 in the US. That's more deaths than have occurred on any wars and military conflicts in the last 80 years combined, and over 3.6 million worldwide. And again, that's a low figure. It's really just been a staggering problem that has confronted all of us, and it has resulted in these unprecedented shutdowns of social, educational, and economic activity that were designed to reduce the spread of COVID-19. I use that word unprecedented advisedly. None of us had ever been through this before. As this was, the pandemic was exploding last March and April and May, I was getting calls, and I suspect that many of you were getting calls being asked, well, what do we do to respond to this? And the answer for all of us was, we don't know. We've never been through anything like this before. And we're all making it up as we go along and dealing with changes in state regulation and federal law designed to mitigate the spread while at the same time trying to minimize the impact on the economy. Part of those changes were Michigan's work from home order that was originally issued by Governor Whitmer, and then after that was found to be not in keeping with Michigan law by the Michigan Supreme Court, was incorporated into emergency rules that were promulgated by MIOSHA that required everyone to work from home whenever practical to do so. Thankfully, progress in combating the pandemic, including widespread use of vaccination, have resulted in that work from home order being lifted effective on May 24, 2021, which is what brings us all here today. There were these revised MIOSHA rules that were issued and became effective on May 24, 2021. There was a handout in the business section of the GoToWebinar. If you want to click on that, you can download a copy of those rules if you want to follow along or review them if you haven't done it already. Those rules became effective on May 24th. They're fairly short and simple compared to what was out there before, but they do warrant a good review. Those rules are set to expire by their terms on October 14th, 2021, not on July 1st, 2021. There's been a lot of communication coming from the governor's office about how all restrictions are planned to be lifted on July 1st, 2021, assuming there's not a flare-up of the pandemic. That is true with regard to the DHHS order that's sitting out there. MIOSHA's rules are set to expire on October 14th, 2021. Now, that doesn't mean that they can't change that date going forward. There was a Q&A that was done with MIOSHA last week when the question was asked as to how long these are going to last, and the answer was, well, we don't really know. They're going to expire by their own terms on October 14th, but depending on how things go, we may rescind them altogether. We may modify them again before October 14th. But for now, those are not planned to expire on July 1, so it's not a matter of just waiting us out for another month and they're going to go away. They're going to still be sticking around for a little while longer. That's not all bad. The good news is that first, these are much more simple rules than existed before. They're a lot easier to interpret and to understand. Second, it's to employers' advantage to comply with those rules. Not only are required to do it under MIOSHA, but the Michigan legislature passed a law last October, the COVID-19 Response and Reopening Liability Assurance Act, a mouthful, which grants immunity to employers who, from liability associated with exposure to COVID-19 in the workplace, provided that they are in compliance with, and this is a quote, all federal, state, and local statutes, rules, regulations, executive orders, and agency orders related to COVID-19. So the key here is full compliance. If you're non-compliant with any part of the MIOSHA orders or any other orders that are applicable to you, the immunity is not going to be available if someone in your workplace gets ill. On the other hand, if you are in complete compliance, it creates a shield for your liability. So that makes making sure that you're complying with those MIOSHA orders that much more important. And of course, there's bad news here too, right? We're not back to how it was before. That's what we all seem to be waiting for, is the idea of, well, when are we just done with this and everybody can come back to work and we can be finished? And then the unfortunate answer is, well, not quite yet. So where do you find the MIOSHA rules? Well, obviously you can get them in the handouts that I sent around. They're available on the internet as well at the website that you see linked there. That is where they'll be updating those rules as they become effective. So keep going back to MIOSHA whenever you start hearing things in the news about MIOSHA changing the rules again, or the workplace rules changing. That's the place to go and see what the current rules are. MIOSHA has a fairly extensive public publicity program where they are reaching out through GoToWebinars of their own, as well as doing question and answers that they publish on YouTube. So if you have questions, if you need more instruction, you can always go to those MIOSHA websites. It's a good place to look, as well as obviously addressing it with your counsel. So what do those rules require? Well, first, and most importantly to everyone, you no longer need to work from home. That has finally gone away. It's great news. People have been waiting that for a long time. So whether it's practical for people or possible for people to continue working from home or not, employers can recall their employees to come back to work as long as they comply with the other rules that MIOSHA has issued. One of those rules is that all employees in the workplace have to complete that daily self-screening protocol. So if you've been having employees come to the workplace, in a lesser capacity before May 24th, you're familiar with this, where there's sort of the magic questionnaire everybody needs to answer on the way in the door about whether they've been exposed to COVID-19, whether or not they're suffering from any symptoms of COVID-19, they've been engaged in international travel. The questionnaire requires that you ask if any employee or contractor entering the workplace has symptoms of COVID-19 or suspected or confirmed exposure to persons with possible COVID-19. The MIOSHA did not provide us a sample questionnaire to work from as part of this guidance, so you do need to draft something. I'd recommend that you go to the CDC protocols about what those symptoms would be for an explanation as to what that's going to be. A couple of things to bear in mind there. First, there's no longer any requirement for a temperature check until May 24th, when people were entering the workplace. You had to zap them with that infrared thermometer to see if they were running a fever. That is no longer required. You can still do it if you want to. The EEOC permits temperature checks while the global pandemic is ongoing. It's not seen as a medical examination that's governed by the Americans with Disabilities Act, but you don't have to if you don't want to anymore. And most employers, at least that I've spoken to, are discontinuing that. Second, you can, there's sort of a tension between the questions that you're having to ask and how you react to them. Because if you recall, the question you have to ask is whether a person has been exposed or not. But the MIOSHA regulations don't require that you bar entry to someone that has been exposed. And the CDC guidance on that is that if a person has been vaccinated or has tested as COVID positive and recovered in the last 3 months, so they've already been sick, they're not required to quarantine if they're simply exposed. So it's not clear of exactly how MIOSHA is dealing with that on the exposure front. However, simply having been exposed if you're vaccinated is likely not a bar to entry, but is something that needs to be developed through further guidance from MIOSHA. The rules also require that if you have any positive or suspected positive employees, they have to be sent away, returning only when they're no longer infectious pursuant to CDC guidelines. Those have been a moving target as to what it means to no longer be infectious under CDC guidelines. As of last night, the guidelines were you are no longer infectious 10 days after your symptoms appear and 24 hours of having no fever without any medication and all your other symptoms are improving. Or if you don't have any symptoms, 10 days after your positive test. So that's what you're looking for before people can return to work. Now, bear in mind, last October, Michigan's legislature passed a statute to protect employees who test positive. And for the lawyers among you, you can find it at MCL 419.401. It's called the COVID-19 Employment Rights Act, and it requires any employee who tests positive to stay home and complete an isolation period, and an employer is prohibited from taking any employment action against them because of their absence. There's similar requirements for people who are experiencing symptoms or who are in close contact with a COVID positive individual. Close contact in that context means within 6 feet for 15 minutes or more. The close contact piece is a little bit in question because of some language that says if there's public health guidance that would allow a person to return to work earlier, they're permitted. We have some CDC public health guidance for vaccinated individuals, so there's some tension about exactly how that works now as well. But basically, positive employees, symptomatic employees, and exposed employees that aren't vaccinated would need to go home for a quarantine or isolation period, and they can't be discharged for that absence. They're protected under this Michigan statute. The new MIOSHA rules also require that you give notification to any coworkers, contractors, or suppliers who come into contact with the COVID-19 positive employee of that exposure within 24 hours. Now, this is more expansive than the close contact standard that we were talking about earlier. This is any contact as written in the MIOSHA rules. So if there's been any incidental contact, you still need to give that notification to the employee. You do need to continue to keep the identity of that employee confidential unless they give you permission to reveal it. And you would go to and you need to keep a record of what the notification is as part of the MIOSHA requirement as well. So it's not only just reaching out to those employees, but keeping track of who it is that you contacted and what you told them and when. So what else do the rules require? They require that you have a current COVID-19 preparedness and response plan and an on-site coordinator. You should already have one of those on hand if you've had employees in your workplace since the pandemic began. That was a requirement of the old MIOSHA emergency rules as well. You will need to modify that preparedness and response plan to reflect, new monitoring requirements, masking requirements, etc. But it really is not a major lift to go through your old preparedness and response plan, compare it to the new MIOSHA emergency rules, and bring that up to date. You don't need to start from scratch. You also do need to continue to have that on-site coordinator responsible for implementation of the plan each day. The rules predictably continue to require you to promote hand washing at work, and providing hand sanitizer if soap and running water is not available. This is the posters that you've had up probably since last April or so. Just keep those up to promote hand washing at work. If you're in a workplace where soap and running water isn't readily available, make sure hand sanitizer is available to the employees instead. Good news on that is you can actually get hand sanitizer now versus where we were last April and May. So at least we're making progress on that front. You also need to make sure you're doing training for all employees in infection control practices, workplace infection control, and how to report unsafe working conditions. Exactly what that training is a little bit vague from MIOSHA standards. You can use the CDC guidance. However, they have a tab there for employers to talk about how to discuss infection with your employees, as well as some videos that you can use to show there. But it includes things like, and one mandatory point that's required by MIOSHA is that you need to educate employees about vaccination as part of infection control practices. That needs to be included as part of your discussion, as well as PPE, what the symptoms of COVID are, and how to report unsafe working conditions or exposures in the workplace. Again, there's no particular training format. You can do this in a live session if you prefer to do that. You can do it through a video that you broadcast that's recorded. You can do it through a live video, through an audio, a brief morning meeting. It really is up to you. You are required to document, however, that people have attended and participated in that training. If the plan changes at some point, or you get new information about COVID-19 transmission or diagnosis is released by the CDC, you'll need to retrain on those points. But MIOSHA is not requiring that you redo the entire training, just to update it to include that new stuff. You'll need to keep records of the training, the health screening protocols, and any reports of those required notifications for 6 months. So all this is pretty easy so far. It's kind of a paperwork process, but nothing that's terribly difficult. Where things get a little more complicated is when we start dealing with how we're going to treat our employees. MIOSHA has rolled out a differentiation and how you're going to treat your vaccinated and your unvaccinated employees in the workplace. This is really consistent with the most recent CDC guidance that came out in late May, but before these regulations came out. And what MIOSHA has said is that for your vaccinated employees, they are no longer required to either socially distance or wear a mask in the workplace unless you're in a healthcare setting or on public transportation, which has its own set of rules. So that's easy enough for those folks. They're basically back to normal if they've been vaccinated. Your unvaccinated employees, however, have to continue to socially distance by 6 feet, which is the same as we had before. Or if that's not possible, to wear a mask, a non-medical grade mask. You're not required to issue N95s to people, but those non-medical grade masks have to be made available by the employer. So that's fine in theory, and it kind of makes sense given what the CDC has said. But it does raise a question, and that is, how do you figure out who's vaccinated and who's not? And MIOSHA has taken an interesting position on that. They basically have said, in a statement that's not terribly helpful, that any method that allows or any manner that's deemed effective for the workplace in determining who's vaccinated and unvaccinated is acceptable to them. But doesn't give us a lot of guidance. They do have 4 suggestions. One is you can require an employee to show proof of their vaccination and to keep a copy of their vaccination card. That's fine. Some employers are doing that. It does create a paperwork issue that you need to keep those cards, and then you need to maintain those as confidential medical records. Some employees are pushing back against that as a privacy issue. They don't want to display the card. But that's really a more management related issue. You do have the right to demand and see a copy of the card in order to give them the privileges of a vaccinated employee if you wish to do so. Another method that MIOSHA has sanctioned is saying, look, you don't have to ask for people to submit proof. You can simply post signs and inform and educate your employees that if they're vaccinated, they aren't required to socially distance or wear a mask. But if they're not vaccinated, they have to keep doing that. But not actually provide any documentation. And that's okay, but it really creates a trust issue. A lot of employees are very hesitant to return to work right now because they're scared about getting exposed to COVID, even if they've been vaccinated. There are breakthrough cases that are out there. And so they don't want to report to the workplace if there are employees who are unvaccinated who are wandering around that aren't wearing a mask. And if you go down this road of simply posting signs and relying on people, the honor system for people to comply, that may or may not be enough to make them comfortable with their workplace situation. Again, that's a management issue you need to work through, but keep that in mind as you're rolling out that policy. Another possibility MIOSHA raises in dealing with this idea of differentiating between vaccinated and unvaccinated employees is just saying, well, just keep working from home. You can continue doing remote work, and then you don't have to deal with the question. But that sort of does beg the question, right? We're trying to get people back in the office. That doesn't really help. And then finally, the option that MIOSHA suggests, the fourth option is just require social distancing and masks for everybody, regardless of their status. In my experience, a lot of employers are ending up here in the short term. The concern is that they don't want to get into the culture wars over vaccination. It's become very politicized, and they're basically just saying, look, we're going to have people come back to work, and in the short term, everyone's wearing masks, everyone's continuing to socially distance, and that's how we're going to handle it. The downside, of course, there is for your employees who are vaccinated, they don't get a benefit of actually going out there and participating in the vaccination process. But it avoids a more difficult issue of employers having to play police and differentiating between two employees, remembering who's vaccinated, who's not vaccinated, et cetera. And then they can just revisit that issue in a month or two, and hopefully this MIOSHA guidance gets reformed further. Another issue that's raised but not really confronted by the MIOSHA regulations is what about employees who haven't had COVID-19? CDC has recognized that they have some level of immunity, at least for a period of time. Are they treated as vaccinated employees or unvaccinated employees? And the short answer there is MIOSHA has said in its Q&A that if they've simply had COVID-19 but have not been vaccinated, they are treated as an unvaccinated employee and have to continue to socially distance and wear a mask if they can't socially distance in the entirety. Like I said, not entirely consistent with how the CDC has viewed this, but that's where they are. So that raises the next question of, okay, we're going to get people back to work. How do we want to deal with requiring vaccination or not requiring vaccination? There are sort of four different schools of thought on how to proceed with this. Early on, the trend was to pursue mandatory vaccination, at least in a larger degree. Not all employers, but there was a survey that was done by a law firm, Fisher & Phillips, back in January, and vaccination was really coming online. Back in January, about 10% of employers were saying that they were going to require mandatory vaccination for all employees to return. They redid that survey last week, and it's down to 4% and falling, that fewer and fewer employers are going to mandate vaccination at return. When asked why, most of those employers said, well, first, people who want to be vaccinated seem to largely be vaccinated at this point, right? We don't need to encourage them to do that. If you want to go get vaccinated, it's not too tough to get a shot these days. And we don't really want to get into the middle of why people aren't getting shots. And we also want to be able to avoid some of the more complicated accommodation questions that arise when people are mandated to get a shot but then can't because of religious objection or a disability or for other reasons. And we'll get into that in a little bit more detail later. So if you're not going to require mandatory vaccination, and you can require mandatory vaccination, don't get me wrong, it is permissible legally. It's just a matter of whether or not you want to fight that battle. Some employers are providing incentives ranging from time off to get the shot, to monetary incentives, to prizes or whatever it might be. You get entered in a workplace lottery as an incentive. There was a lot of confusion about whether or not, excuse me, those sorts of incentives are permissible. The EEOC cleared that up last week with some supplemental guidance. If you haven't, by the way, looked at the EEOC guidance regarding COVID-19 in the workplace, go to their website. They have a link at eeoc.gov directly to that. It is pages and pages of the EEOC's position on various issues that arise regarding COVID-19 in the workplace and the Americans with Disabilities Act and the Genetic Information Non-Discrimination Act and Title VII religious accommodation and other issues. Worth a read if you're going to be dealing with employees back in the workplace and those discrimination issues. Anyhow, the EEOC clarified that incentives are okay and that you can require proof of vaccination from an employee in order to qualify for that incentive. provided they got the vaccination from a third party. So if they went to the local Rite Aid, the local health clinic, got their shot, they can be required to show the card in order to get the incentive. That's fine. They also said that if an employer is either giving vaccinations itself or partnering with an agency, so if you had, for example, Rite Aid come in, give vaccinations on site, or a local hospital come in, give vaccinations on site as an agent, it's okay to give incentives for that as well, as long as the amount is not quote unquote coercive. And the idea there is we don't want to pressure people to reveal the confidential health information they have to reveal in order to get a vaccination. What is a coercive incentive? Your guess is as good as mine. I think it's something that's large enough that people would feel they don't really have a choice but to turn it down. So if you're going to offer, your minimum wage employees thousands of dollars to get a vaccination, I think that would likely be seen by EEOC as coercive. But exactly what they mean by that is far from clear. In any event, you need to keep the records of that vaccination confidential if you get them as part of the incentive program. Another route that employers are pursuing is the idea of simply recommending. That seems to be the most common route people are pursuing, that to inform the employees of the benefit and the safety of the vaccination process, let them know where they can get vaccinated, and the hope is they sort of arrive at the conclusion they want to go get vaccinated on their own. It's seen as less coercive, less interfering by an employer and their employees' personal decisions. And then finally, some employers are simply going with the don't ask, don't tell, which is, look, we're not asking if you're vaccinated or not. We're going to require everybody to either mask up and maintain social distancing, and we're going to do postings, and we're just not going to get involved in that conversation. It really de-emphasizes the idea of vaccination at work. Again, you're seeing some employers taking that position because of the politicization. How political? How about that? How political the idea of vaccination has become. They don't want to get in the middle of that conversation. For those who decide to have mandatory vaccination, there is an issue with the employees who either can't or won't be vaccinated, and in the face of that mandate. That's simply the nature of the beast. So the key here for employers is knowing why the employee is refusing to be vaccinated. If the employee is refusing to be vaccinated because they have a disability that prevents them from being vaccinated, so for example, if they're immunocompromised and can't get one of the vaccines, at that point you need to engage in the interactive process just like you would for any other accommodation of an employee with a disability. You're going to be looking at that question of whether it's an undue hardship, that is, does it create a significant burden of expense, and you can include things like the harm to the employee or others resulting from the refusal to get vaccinated. There's a lot of moving parts here. The position the employee is in is going to be important. Is it something that is public facing? Is it something they're going to be working, in a back room by themselves and not really exposed to other people anyway? The industry is going to be important. Healthcare is obviously going to be much more sensitive to this than, for example, a factory position. The types of accommodation that you would look at would be things like, continuing wearing masks and social distancing, rather than getting a vaccination, doing more frequent testing, potentially reassignment to another position, potentially continuing to work from home. It can be the whole spread. But the EEOC has been clear that you can consider the proportion of employees in your workplace that are vaccinated in determining what might be a reasonable accommodation. So if you've got a 99% vaccination rate, this employee is the only one that's going to be coming in, it might be a reasonable accommodation to simply say, well, you're going to continue to wear masks and socially distance while you're at work. Everyone else is vaccinated. The chance of you infecting someone else is essentially zero. The chances of you getting infected are essentially zero. So that's a reasonable accommodation versus a workplace where you may have 10% vaccination take rate where that may not be a reasonable accommodation. Again, this is a very individually sensitive issue. You need to have a conversation with employees in each one of these instances about exactly what their needs are, what their position is, and how it may be accommodated. Similarly, in a religious context, you need to accommodate there as well if somebody has a religious objection. The accommodation process is extremely similar. The one thing that's a little bit different that some employers get hung up on is whether or not this is actually a sincerely held religious belief. My recommendation to you on that would be not to get too hung up on the question of whether or not it's a sincerely held religious belief. That's somewhere you would get in fights unless there's an objection that's objective, right? If you know that, for example, the employee has a strong history of being an advocate for vaccination, they use healthcare all the time, they're very engaged in the public health system, for them to suddenly take a turn and say, well, I don't believe in vaccination and it's a religious objection, or I don't believe in medical care, that might lead to a question where you want to have additional support provided from the employee. The other circumstance would be, you have an employee that is anti-vaccination based upon personal non-religious beliefs. They believe that the vaccines are useless and this is all a fraud. And then when they're told, well, that's fine, but you don't get accommodated for that, all of a sudden they have a sudden convenient conversion to religion. That might be a point where you can have a deeper conversation. This is an area, though, where you're going to want to get counsel involved and really talk to them carefully about exactly what you're asking, what information you're asking for, and how to process it. Finally, there are some employees who aren't going to get vaccinated because of a personal non-religious belief, and that's fine. That's their prerogative. That is not something that you have to accommodate, however. And you can tell that person, well, your option then is, if you don't want to get vaccinated, to find a job somewhere else, and that is entirely within your rights as an employer. So the other thing you're going to be dealing with is other employees who don't want to come back to work, and there's a lot of reasons employees might not want to come back. First, the employee might say that they are personally at risk. They are immunocompromised. They have a disability that makes them particularly susceptible to COVID-19 infection and/or to severe infection or death if they do get infected. Again, that might be a disability that you need to accommodate. You'll need to have a conversation with those employees about exactly what their disability is, about what accommodations you can put in place. That might not mean they continue to work from home. It might mean that you can give them, an office that's more isolated. They continue to wear, masks, et cetera, continue to socially distance. Other people are instructed to continue to socially distance from them. That's going to be a very individualized inquiry as to exactly how to deal with that employee and how you're going to want to engage in the interactive process. One thing to point out there, though, is that the EEOC has been very clear that simply being an older employee is not a risk factor that you have to accommodate. While older employees are at risk, that is not something you have to accommodate under the Age Discrimination and Employment Act. It doesn't have accommodation provisions in it. Now, that doesn't mean that even if these things aren't disabilities, that you might not want to have a conversation with the employee and accommodate them anyway, simply to get them back to work and as an outreach as a good employer. But you aren't required to legally do that simply because age is the risk factor that they're suffering from. Similarly, if you have an employee who's fine personally to come back to work, but they have a spouse or a family member that's at risk and they're concerned about exposing that person as a result of returning to work, that's not something that you have to accommodate according to the EEOC under federal accommodation laws. Again, that's something you might want to have a conversation with that employee, and you might want to put some things in place for them simply because you're trying to get them back to work and work with them as an employee, but legally there's no obligation to accommodate because a spouse or family member is at risk. Another thing a lot of employers are running into as they're trying to get employees back to work, particularly given the time of year this is happening because schools are about to let out, are childcare issues. Some employees are unable to return to work because they don't have childcare. The day camps or camps that they were going to send kids to are either closed because they are concerned about continued COVID exposure, or because they can't get employees to work there because of an inability to bring in overseas workers to the United States. Those childcare issues are a reality. A couple things to bear in mind there. First, if you've opted in to the American Rescue Plan FFCRA extension that runs through September 30th, they may be able to take an extended FFCRA leave at partial pay and get paid by the government. That's a matter of whether you've opted into that or not, and whether or not they meet the criteria for the child care supplement for that period. You also can help ameliorate this issue by giving some notice of return to work. Where this really starts to become a problem is when you announce to the employee on Friday that Monday everybody's coming back to work, and they're caught shorthanded because they don't have child care in place. Giving people a couple of weeks or a month to make those arrangements and get people back to work goes a long way towards ameliorating this issue. Otherwise, the child care issue, that's really the employee's issue. That's not an excuse for them not to return to work if they've been ordered to return. It's their obligation to get that issue lined up, just like it was before the pandemic. And the final one is one that's going to come up a lot, which is people just prefer to work from home. We've all been doing this now for a year. For a lot of employees, they really like it. I don't happen to be one of them, but people like to work from home. It's going to be an issue getting people back to work because it's something that they've gotten used to, and in their view, and in the view of many managers, it works just fine. It's going to be a competitiveness issue for companies going forward as to whether they're going to offer some sort of work from home or hybrid solution in the long run, even though we're not any longer in the pandemic. It's going to be an issue for competitiveness locally. that employers locally who are competing for talent can say, well, you can work home 3 days a week, only come in 2 days a week, or come in for meetings, or don't come in at all. And it's also going to be an issue for competitiveness on a national scale. More and more employers that are on the coast that pay a fairly high salary, whether they're in Los Angeles and Seattle and New York, in Boston, are looking to the Midwest and seeing that there's actually talented people here, and that the reason that they aren't working in Boston or New York or Los Angeles is because they don't want to move. But they're saying you can work from home, we'll pay you more than you would make working for a Detroit employer, less than you make if you're working in Boston, but you get a higher standard of living out of it, and you get to work from home. And a lot of employers are losing employees to that. So you need to think about how you want to work with that as far as a policy you're going to set up going forward, just from a competitiveness standpoint, and how you're going to compete to keep that talent if you're not going to allow people to work from home at least part-time. There was an article in Bloomberg this morning where they surveyed a number of Gen Y and millennial, or Gen Z and millennial employees, and asking what their attitude was from returning to work full-time. And over 40% of them said, if there's no work from home policy, at least that I can work part-time from home, I'm looking for a job. So it's going to be a reality that we all have to deal with going forward. A few considerations to go through. We talked about most of these, but just a checklist for you. Make sure you go through, review all the applicable public health orders in advance. Those might be the MIOSHA orders. Obviously, you're going to want to look at that. Like I said, it's not a bit heavy lift to read through that. But if there are particular orders that are unique to your industry, look at the DHSS orders. Make sure you go through that stuff, have a good handle on what the requirements are for you to proceed with. Second, consider reopening in phases rather than simply having everybody come back at once. That helps you work through some of the kinks of getting things opened back up. You're going to find out inevitably when people come in, there's stuff that just isn't working because either you're in a large building, people need to go through a check-in process that the landlord's put in place. There's social distancing being enforced on the elevators, so you can only get 4 people in an elevator at a time instead of the 15 that used to ride up at 9 o'clock in the morning, et cetera. There's a lot of other things that could happen. Building it gradually to make sure that you work through that issue and that your printers are working and the coffee makers still function is going to take away a lot of headaches for you in the longer run. Decide how you're going to address vaccination status reporting and whether you're going to mandate vaccination for returning employees. No right or wrong answer to this, but it's a question each company is going to have to answer for itself and decide how they're going to deal with that, and then accommodate the employees that aren't able to get vaccinated for whatever reason. If there are additional safety precautions that you need to implement to be consistent with MIOSHA, get them in place before you have your employees that show up. Make sure you've got your plan in place, you get your social distancing lined up to the extent you have employees that need it. And then consider whether some degree of post-pandemic remote work is right for your organization. It's going to be a challenge that all of us are going to have to deal with. So a few miscellaneous questions that have come up in the course of me having conversations with people about this topic. We've covered a lot of these. But first, can an employer require vaccination of employees to return to work? The answer is yes, you absolutely can. However, you do need to open up the issue of accommodation for people who have disabilities or religious reasons for not getting vaccinated. Can an employer require an employee to show a copy of their vaccination card and keep a copy of their files? Yes, you can require that. The copy of that card does need to be kept as a medical record, however. That means a separate locked medical file, separate from the employee's personnel records. Are employees required to do the daily temperature screenings? No, that is gone, finally. We no longer have to do those things, and you can do it if you want to, but you can put away your infrared thermometer. How long are employees required to keep those MIOSHA screening sheets? You have to keep that stuff for 6 months. You don't necessarily have to keep the hard copy. Feel free to scan it or create a web form to have people check in. It doesn't have to be paper, but you do have to have the documents available for MIOSHA to look at if they should come and do an investigation. Can an employer segregate employees according to vaccination status to reduce the risk of spread at work? I think the answer to that one's yes. This is sort of a matter of some controversy. It's not an adverse employment action to say, look, we're going to keep our vaccinated employees over here and non-vaccinated folks over there. It does create an issue of disclosure, but you're going to have the same problem if you have the mask mandate where vaccinated employees don't have to wear a mask. So they're going to be self-identifying as people who are not vaccinated. If you are going to do that, I would require people to show proof of vaccination status so you don't have people contaminating your non-vaccinated pool. And finally, are there state laws that would prohibit discrimination based on vaccination status? Right now in Michigan, the answer is no. The only state I'm aware of that has passed that law is Montana, that has a law against discrimination based on vaccination status. And that is both in the public sector as well as in the private sector, so you can't bar access to a place of public accommodation, et cetera. There is a bill pending in the Michigan legislature. It's sitting in committee right now, but to my understanding, it hasn't gone anywhere from there. And I would be surprised, given our current governor, if that were to be signed into law. So a few questions that we have. Let me take a look at what has been asked and see if I can answer at least some of these. Fortunately, we've had enough. Fortunately or unfortunately, I've had enough questions that it scrolled a bit, so I got to move up. So if a non-vaccinated employee says they're sick, do they use their paid leave or COVID leave? And if COVID leave, can the company be compensated? So this is if an employee has opted in to the continued FFCRA leaves through September 30th, they can use their paid FFCRA leave for that 2-week period, and the company can be compensated up to the caps that are provided for under the law, and it's done through a payroll, basically withholding part of your payroll tax deductions. Question, can there be more than one on-site coordinator? Yeah, you can have more than one person do that, and most companies are doing that simply because that way if the person's absent, they have somebody that's there to follow up. Possible to receive a copy of the PowerPoint. I'm going to leave that to Lori to address when she gets back on the line. I'm not sure of how that would work. I don't have a problem with it being shared. I just don't know how it would go out, be handled mechanically. So I'll let Lori handle that. As an employer, if you encourage, require, incentivize, or otherwise influence to get the vaccine and they had an adverse reaction, can you be held liable to that employee and or their family? I think the answer to that is no. I mean, that doesn't say that you're not going to get sued, but you're not obligating the employee to get the vaccine. They always have the option to say they're not going to get the vaccine and find a job elsewhere. If they do get that, it would be a workers' compensation claim at worst, I would think. And the cases that have come down on that so far have said that workers' compensation would also protect from claims from the family arising from that exposure. Am I in violation of HIPAA, ADA, AMA, or federal law by getting involved in the discussion at all? The answer to that is no. You can have that discussion. Again, you have to keep it as confidential. Is proof of vaccination required? I think that's in the context of if you're going to require people to wear masks or not wear masks under the MIOSHA mandates. OSHA has said that you don't have to get proof of that documentation, but that is one way to comply. You have to have some mechanism in place that's reasonable for your industry to make sure that only people who are vaccinated are not wearing masks and socially distancing, but that can also be done through postings, et cetera. Any specific updated rules on public transportation other than wearing masks? For example, is there still a passenger capacity limit? Sorry, I don't know the answer to that one. I assume that there is, but you need to look at the particular regulations that the Department of Transportation has issued on that in the CDC. Since the vaccine doesn't use human tissue, are you required for a religious reason to not be vaccinated? And where some religions have vowed on vaccines that are using unborn fetal tissues. So the mRNA vaccines are not tied to fetal tissue. It's just the Johnson & Johnson vaccine that is using that stem cell line, as I understand it. Not a doctor, not a scientist, but that's my understanding from what I've read about that. However, there may be other religions that have prohibitions on vaccination in general. So again, that's a conversation you need to have with the employee about what their specific limitations are. Is there objection to getting a vaccination that's using a stem cell line using unborn fetal tissue? If so, is there a reason you can't get vaccinated using Moderna or Pfizer? That might be the accommodation you use. You're not going to use the Johnson & Johnson we're offering here, but you can go to Rite Aid and get your Moderna vaccine, and that will be fine. Copy of the presentation, I already talked about that. How does MIOSHA define training? That's an excellent question. The question was, will an email document posted information satisfy training, or must it be verbal, Zoom meeting, or webinar? What about putting a sticker on a badge to show vaccination? Oh, we changed questions. So as far as training goes, I think that they have in mind some sort of something more than simply sending out a document. It is not clear what they mean by training, but in other contexts, when they're talking about training, they're typically talking about some sort of instruction. So not just sending a document to people, but actually getting some interaction with them, whether that be through a broadcast like this one, a one-on-one meeting, a meeting in a classroom. It doesn't need to necessarily be long, but I think it needs to be more than simply sending out a document. What about putting a sticker on a badge to show vaccination status? Is there an issue with showing vaccination status? I don't think there's an issue about putting the sticker on a badge to show vaccination status. You may get pushback from employees about doing that. They may not like having that on their badge, but the reality is if the only way you can not wear a mask and not socially distance is if you're vaccinated, then we all kind of know, right? If you're not wearing a mask, you must be vaccinated. That's the only way that you can be wandering around the office. So I have a hard time believing that there's an issue with that as a disclosure. Should new rules, regulations, including pandemic language, be added to an employee handbook? That's a very company-specific question. My inclination would be no on that. I'm not a proponent of putting something in an employee handbook that deals with every possible scenario that might be confronted. And hopefully this is the one and only time we're going to be dealing with the pandemic scenario. So adding something now about in the case of a future pandemic, here's how we're going to deal with it. Seems like we're closing the barn door after the horse has already left. I don't see a need for that down the line. If you want to have a policy that you roll out if something should happen again, and boy, I hope that never does. We can cross that bridge when we get there. But hopefully, this is a once in a generation issue and not something that you need to include in a handbook. How should we treat clients and vendors in terms of mask wearing and temperature checks? So the MIOSHA regulation talks about both. It's obviously focused on employees, but talks about contractors, including contractors, and making sure they do the questionnaire each day. So they do need to do the questionnaire. There is no requirement for temperature checks. As for mask wearing, I don't think that OSHA really speaks to that question clearly. But I think that you can ask the vendors to wear a mask unless they're willing to disclose their vaccination status to you. If they're willing to do it voluntarily and you're willing to treat them as employees who are vaccinated, then I think that's fine. But I wouldn't mandate them to tell you. So I think I worked through all the questions. I'm 2 minutes over the clock, and like I said, I'll try to be respectful of your time. But Laura, I'm going to hand it back to you. If maybe you could answer the question though, whether it's possible for us to send out a copy of this PowerPoint deck to people.
Yes, I want to thank you first of all for your time today. That was an excellent presentation. And for the participants, I will be sending an email later this afternoon with a link to the recording of this presentation. And with that email, I can include the PowerPoint and the handout. So that's what I will plan on doing. It probably will be a couple hours before you see that email from me, but it'll be coming directly from me. I want to thank you for your time today. And please visit our website, DetroitChamber.com, for more upcoming webinars that can help you in your business. And again, a thank you to James and Dykema for participating in today's discussion. Have a great rest of your day.